Let's get reaction right now. Legal analyst Melusi Xulu joins us for more on the inquiry. Mr. Xulu, good to have you on the program this evening. To start, what stands out to you most about the fact that Shamila Batohi is now being cross-examined in an inquiry that she initiated, really?
Good evening to you, Nhlanhla, to the viewers at home. Thank you for having me. For me, one of the outstanding issues is what is seemingly a lack of preparedness, and how even the commissioners asked her. I mean, when all the commissioners are asking you a question that is based on the same foundation, I mean, that's concerning, they were asking her, when you prepared your affidavit, were you preparing it in line with the terms of reference? And she said that she was just preparing an affidavit to give evidence, and it was not in line with the terms of reference. So for me, that was quite interesting. And but the fact that she initially didn't want to be cross-examined, it gives you something to think about. That I think she was aware that whoever was going to cross-examine her was going to expose certain issues that we saw coming out today.
Yeah, speaking about that, Mr. Xulu, and also given the tension that we saw last week as well about whether Batohi would ever be cross-examined at this sitting, how significant is it that the chair actually insisted that she must be cross-examined? What does that say about the fairness of this process, really?
I think what stands out for me in relation to that is the fact that the chair is here to ensure that an investigation is made into the inquiry, based on the inquiry, and into the fitness of Advocate Chauke. But at the same time, it's important that if you are a witness or a complainant, whatever you've stated, if the person who's being charged has an attorney or an advocate, like in this case, Advocate Nkabinde, and he wishes him to come and challenge that evidence, it's important that you are cross-examined. It's part and parcel of the procedures in what we have in law. So I think for me, it was important for the chair to highlight the fact that she must be cross-examined so that at least her credibility can be tested, because that's what cross-examining gives us. It gives us the fact that you've given evidence, and whether what you've given can be tested, and your credibility, so that at least we go down to finding out the truth. Because at the end of the day, Tasha, we are here to find out the truth, whether Advocate Chauke was fit and proper based on the allegations that have been stated on the terms of reference. So it was important that she's cross-examined. And
you mentioned the name of Advocate Tembeka Nkabinde, who's Chauke's legal representative. He's known for his rigorous line of questioning as well. Let's get your sense as well of the kind of strategy that's being used to really poke holes at the allegations that are being made by Batohi. What do you make of it?
Well, for me, what is interesting is we must start at the opening statement, where they focus on the fact that nowhere in the evidence is it clear whether Advocate Chauke violated any law, especially based on Section 12, subsection 6 of the National Prosecuting Act, which is what this inquiry is based on, and the fact that they're looking into the fitness and the fitness of Advocate Chauke. So what he was stating was the fact that, look, there's no corruption, there's no bribery that can be proven. What is important is prosecutory discretion. When you're making a decision, for example, in the Richard Ndluli case, you're making a decision, you're saying, at this point, I can't find evidence that is enough for me to prosecute. Therefore, I'm declining to prosecute. And as a prosecutor, you can say, can you find out or add certain evidence, or a certain evidence, so that at least I can make a proper decision. So that was what they were basing it on, that it didn't need to come to a commission of inquiry. It was just to understand that he had the authority and the discretion to make the decision that he made. And it was nowhere near corruption, bribery, or any sort of misconduct that is being alleged.
Also interesting, and you've mentioned it, this inquiry hinges on Chauke's decisions in the Boysen and Ndluli matters as well. Let's speak about this. From a legal standpoint, how hard will it be for Batohi to indeed prove that these decisions speak to his fitness to hold office? That's Chauke.
Well, I mean, let's look at the Boysen case, for example. I believe that some decisions that were made the major decisions that were actually made by Advocate Nomgcobo Jiba. And when that matter was taken to a court at a certain platform, it was decided that yes, maybe there were issues, but there was no proof of extreme misconduct. So at that point, it shows that when the case comes to him, he was merely assisting Advocate Nomgcobo Jiba. With regards to, Mdluli, Richard Mdluli, I think we still come to that. So let's wait for that until it comes. But what will be crucial on the Mdluli aspect is the fact that they must prove that he went beyond, prosecutory or prosecution discretion in making his decision, and that he was influenced in some way. Because, for example, in Tlanta, let me make it very plain. If they can prove that Richard Ndluli somehow influenced Advocate Chauke in a decision to not proceed with the case. Now, that is misconduct. That is a proper way of saying there are issues with his conduct.
Right.
But if they can't, and the decision that he made is purely based on his understanding of the law, then it will not be fair to proceed with that aspect. So those are the hardships that I believe will be had if we proceed. But more importantly, I think this is very crucial. The fact that she can't link her evidence to the terms of reference, this is very worrying for me, Nhlanhla. And I know that they'll be amending or they're applying to amend, but it shows a lack of preparedness. And by not being prepared as the NDPP and the head of NPA and, NPA itself, if I would say that, it shows that there are issues with regards to this commission. But I will not put the cart before the horse. There's still some time to go, but it's just that she's one of the key witnesses. And if it starts like this, it's a bit worrying. But let's wait for the full hearing to be done. The Advocate Chauke will also have his time and turn to bring his witnesses and himself being a witness.
Yeah. Mr. Xulu, there was also something I noted, this private discomfort expressed by Batohi toward this panel. Could that influence how her testimony is indeed interpreted at this sitting? Or is that irrelevant once the proceedings do resume?
I think what is important is let's ask ourselves, why is she uncomfortable? If she's uncomfortable because there are certain issues that are worrying that the panel or the defense or rather the advocates of the person who's charged, Advocate Chauke, are bringing to her and she must answer, it's because she needs to answer to that. And if it makes her to be, uncomfortable, it's unfortunate, but she must answer. But more importantly, if she has issues, obviously, that, she believes that the panel will not judge fairly, she always has an option to apply for recusal. But what I like about the chair, the former justice in the Constitutional Court, Nkabinde, she makes sure that everything is brought into the open. So if you call her and you say, Chairperson, I'm not comfortable with being cross-examined, she would bring that and say, look, I was called and there were issues. You said you're not comfortable with being cross-examined, but I'm adamant that you must be cross-examined. So everything is there in the open for us to see that she's judging fairly or she's proceeding fairly and openly and she's transparent. So I understand she may be uncomfortable, but why is she uncomfortable if she's being challenged on issues that need to be clarified properly? Because that will be concerning.
Yeah, or maybe this could expose deeper leadership or governance issues within the NPA. Finally, Mr. Xulu, what outcome, realistically, really, should South Africans then expect from this inquiry? Are we heading toward clarity or more institutional uncertainty at the NPA?
I think, if I'm not mistaken, so far we've had 2 commissions of inquiry, or I don't know if it was or done together with Advocate Mhwebi and Advocate Nomgcobo Jiba, and now it's Advocate Chauke. So now we're asking ourselves, is the NPA dysfunctional in any way? But the fact that we have commissions of inquiry it brings that trust that at least prosecutors can be brought to book if there are issues that they did not do properly. Therefore, if they do not do their job, there will be a commission of inquiry. So that is promising. But what I'm expecting in this one in particular, I think, and probably now I'm putting the cart before the horse, I think we might have a commission of inquiry that is different to the ones that we had before, where it might be an issue that that the evidence was not enough, to say the advocate must be released based on the fact that he's found to be not fit. Because I believe so far, Dantla, maybe something else will come up, but so far, the NDPP, which is Advocate Batohi, is not bringing us anything that we can say holds water so far, because she should be prepared, she should know what she's doing, and she's the complainant in this matter, although she says she's not a complainant. But also, what is very important is the fact that the president, which is President Ramaphosa, cannot on his own come with terms of reference. The person who said Advocate Chauke must be charged is Advocate Batohi. And if she cannot bring what she's talking about and cannot have evidence, then we have a problem.